The following is a sponsored segment from the Higgins Firm.
Welcome back to Tennessee Mornings. You know, the laws governing sexual harassment in the workplace can be interpreted in a few different ways, leading to confusion about who can be guilty of harassing. Here to talk about a case headed to the U.S. Supreme Court is Ann Williams, employment lawyer for the Higgins Firm. Good to see you, Ann.
Good to see you too, Nick.
So is there a difference in sexual harassment within coworkers as opposed to an employer and an employee?
Correct. Employers have more liability, we say, for supervisor harassment. So if it's just coworkers, it's one issue. If it's a supervisor, the court and the laws kind of think of the supervisors acting on behalf of the company.
Okay.
And therefore, the employer is a little bit more on the hook. What the Supreme Court is going to look at, or arguments Monday after Thanksgiving, is what really is the definition of supervisor? Is it somebody who has to have the authority to hire and fire an employee? Or is it just somebody who can direct the work? Because you see a lot of workplaces where maybe you have a store manager who's directing you every day. You never see the person in HR or the district manager who's got that authority to hire or fire you. So is that person a supervisor or not? And the Supreme Court's going to give us some direction on that.
Are the lines still pretty fuzzy on what exactly is sexual harassment?
You know, sexual harassment is broad, and I have a lot of employees or potential clients ask me, you know, is this harassment, is that harassment, or really what makes it? You know, it has to be something that makes the person uncomfortable, and it has to be something that we kind of say is hostile and pervasive, not just one or two comments, but, you know, an ongoing sort of a situation. It could also be, you know, sometimes I still in this day and age see, you know, the supervisor who is what we call quid pro quo, you know, if you do this for me, then I'll give you a promotion. If you don't do this for me, I'm not going to do that.
Right, and that's certainly defined.
Yes, definitely.
How has social media changed sexual harassment and how it's interpreted now with Facebook and Twitter, even texting?
You know, social media is everywhere. You can't get away from it, even though employers would like to insulate themselves, and some have policies saying, you know, supervisors cannot be friends on Facebook with subordinates. You know, how are you going to police that is really, really difficult. The one thing that it does do for a victim of harassment is it gives us some evidence where, you know, maybe 10 years ago, all I had was somebody's word against something else. Now I'm like, okay, here's all my texts. Look at what he said to me or she said to me. Or this is what happened on Facebook. These are my private chats. Or, you know,
and
a lot
it's
of
there
people.
forever.
Oh yeah, we can get all. You'd be surprised at what we can get, and you'd be surprised at what people say. You're kind of like, oh, that's very interesting.
Wow. Well, if you feel like you're the victim of sexual harassment in your workplace and you need some advice, you can contact Ann and all the fine lawyers over there at the Higgins Firm, that number 353-0930, or you can contact Ann personally through email, ann@higginsfirm.com. Thank you so much. We appreciate it, Ann.
Thank you.
Have a good day.